Intellectual property. We are into week 5 and the topic is intellectual property. One of the often most misunderstood areas of entrepreneurship, let's call it that. And also one of the areas that you can make some of the largest, most significant, most painful mistakes. So let's jump in. So what I want you to do is just have enough knowledge to protect yourself and know when to go to the expert. I don't expect you to be experts in intellectual property, but you need to understand the foundation of it. So patents, trademarks, copyright, trade secret, trade dress, how you can apply IP in your future or in your current business if you have one. You're going to look at some real world examples and you're going to create an IP strategy map, how you could leverage IP for your benefit. Unfortunately, this is true. Ideas are worthless until you protect them. Once you put your idea out there in the public, anybody can use it and steal it unless you've taken some measures to protect it. So that's the whole point of this is what is the minimum you need to do to protect your idea? Now, IP, or intellectual property, refers to the creations of the mind, inventions, designs, symbols, names, or artistic works, those that are specifically protected by law. What we do is IP transforms creativity into assets. It monetizes the asset, gives you some protection. Do you agree or disagree that our ideas are worthless until you protect them? So they're not worthless from the creative standpoint. They're not worthless from, maybe your personal perspective. We're talking the market perspective. That's what we mean by so not boxing ideas into just the financial realm, but when you go to get an investment from a third-party investor, one of the things they're going to look at is what have you done to protect your IP portfolio. Patents, one of the biggest areas of, frustration for me because everybody wants to patent everything, and that's just not possible. So patents are not enforced by the U.S. government or any government. A patent grants you exclusivity to the inventor. So if I patent something, I'm the only person who can produce, sell, distribute that product. If I notice that somebody is infringing upon my patent, meaning that they are copying my patent and then trying to sell it, the court won't stop them. I have to. I have to hire an attorney, sue that company for intellectual property infringement, patent infringement, get a judgment, and then try to enforce that judgment. So this is really serious stuff, really expensive stuff, and big players. So what can we patent? A process. To a limited degree, you can patent a business process. So the most famous being the Amazon one-click checkout. That was patented. New machines, great innovations in machines. Compositions of matter, things that you make, tangible things that you make, or significant improvements upon things that already exist, but they have to be significant. Can I define significant for you? No. At the U.S. Patent and Trademark Office, there are patent examiners, and you must prove to them that your improvement is significant enough, big enough to warrant a new patent. This is the stuff I need you to really know. The requirements, patent must be novel, useful, not obvious to the reasonable person. There are 4 types: utility, design, plant, and a provisional patent application. In the week 5 folder, there's a white paper that gives you a ton of detail on this stuff, so make sure you read and study that. Patent enforcement examples. So patent holders can sue patent offenders. The biggest one would be the Apple versus Samsung smartphone patents. So essentially, Samsung copied Apple products. It ended up in court for a very long time, and it was a very expensive case, probably the most famous intellectual property case. There is a success story that we can talk about. The University of Florida had a patent on Gatorade, which has netted them about $1 billion in revenue. So at large universities, if you invent something in their lab, a lab owned by the university, typically that university owns, if not all of the patent, a percentage of it. Trademarks and service marks, very important. So over here, I've got two examples. McDonald's, see that R in the circle? And see this TM? They're both trademarks. This one is registered with the U.S. Patent and Trademark Office. How do I know that? The R means registered with the USPTO. That means we have paid the fee and officially gone through the process to have it recorded with the U.S. Patent and Trademark Office. Now, trademark law as it exists today is relatively new, let's say. So prior to there being this formal code of law that we had what was called the common law. And so this is a common law trademark declaration. It's free. Anybody can do it. You put it on your brand, your logo, whatever you want to claim a trademark in, and it's that TM. The downside is you haven't publicly told the world that, hey, I'm claiming an intellectual property right, a trademark in this, but it's something. So when I deal with entrepreneurs who are just starting out, have little money, I tell them, you do the TM, and then as soon as we have some revenue, we'll do the registered. Okay? So, trademark, typically used to identify goods. Service mark, services. Okay? So if your company sells goods, provides goods, it is a trademark. If it is a service provider, let's say like a custodial service company, then that is an SM. So registered versus, there's your R, and there's your TM, trademark, service mark, common law. So here we've got the Nike swoosh, and then the McDonald's jingle is a service mark. The most significant thing that I need you to remember from the slide is that the reason we have trademark law, prevent consumer confusion. We don't want 50 slight variations of the Nike swoosh out there on shoes, because some consumers might buy a pair of shoes thinking they're getting authentic Nikes and they're not. So it's really to protect the consumer from confusion. So remember that. Copyright. Okay, quick and easy. As soon as you create something, as soon as that original work, let's say you write something out, could be on a computer screen, could be on a piece of paper, doesn't matter. As soon as that's fixed in a tangible form, that becomes an original work that is covered by copyright. You don't technically have to register it, although there is a process to register, which kind of goes beyond the scope of this class, but it's automatic. So copyrights cover literature, writing, music, software, film, art, architecture. There's automatic protection at creation. However, you should tell people that this is yours. So if you just throw a photo that you took on the internet and somebody downloads it, you can claim copyright, but a judge could say, you know what, you threw it out there on the internet, it wasn't very smart. Why didn't you at least put the C, this symbol, on it and claim a copyright? So you would say copyright with this C in there, 2025 Professor G, and that would indicate that I have claimed a copyright. So how long does the copyright last? Life of the author, the creator, plus 70 years, unless it's a work for hire. So a work for hire is when Disney hires an artist or a writer to create something. So when Disney hired people to create the original Snow White, it was 95 years from publication. So for 95 years, they have exclusive ownership of everything about Snow White. Trade secrets, the most famous, Coca-Cola. right? They don't have a trademark, they don't have a patent. Basically, what Coca-Cola has done is kept the formula for the Coke a secret. The same with Google and their algorithm and the KFC recipe for their chicken. It can go on forever. They simply have to take reasonable steps to protect their secret. Trade dress is really cool. If you go into, let's say, a restaurant business or retail business, you really want your retail establishment to look different from all the others. And one good example of that would be the Apple stores. Okay, this is trade dress. All of this, the way it looks, the unique layout, that is called trade dress, and you can protect it. So if you create a unique layout design for your establishment, and that is central to the value of your business, then that falls under the trade dress. And what you would do if I built one very similar, and so it was confusing to the average consumer, I could sue you for violation of trade dress. And again, it's all about protecting the consumer and trying to avoid confusion. Now, there is some homework this week. There's a quiz, so check that out in Blackboard Week 5 folder. But then you also have an IP protection challenge. What you're going to do is create an IP strategy map and a protection plan. There's full details in the assignment in the Week 5 folder, so check that out. It's due Sunday by 11:59. You can produce a paper, a PowerPoint slide deck, infographic, needs detail, just something that communicates the key components of that. So, thank you very much.